Hello, sir. Good to see you on this channel. And for our viewers, today we have Eashan Ghosh, who's a lawyer in the intellectual property space. And more importantly, he's an author for us, Thomson Reuters. And he's done two editions of his book with us, Imperfect Recollections. So it'll be good talking to him. And he's a person who comes with a variety and a whole lot of experience. So welcome to our channel, sir.
A pleasure to be here, Gauri. Thank you very much for having me.
So to start with, let's start about, this whole conversation, as I said, is about you. So let's start with your journey in terms of, how you came into the law trade, law practice, and more importantly, into a very specific segment, which is one of the highly evolving segments in our legal space today.
Sure.
So we'll start from there.
Okay. Well, I suspect my experience isn't very unique in the sense that when I was going through my high school and early teenage and later teenage years, the process of deciding what I wanted to do with my life was a two-step process. The first step of that process was making sure that I didn't get stuck in something I did not want to do. And then the second part of that process was trying to positively identify what I did want to do. My natural interests around that time gravitated towards things like the media, towards advertising, towards sport, all of which remain big passions of mine. And therefore, my interests were naturally drawn in those directions. And I think that it's fair to say that I hit some very obvious ceilings in terms of my lack of capability in a lot of other directions apart from what would eventually become my career. So I realized that I had, athletic limitations in terms of trying to get involved in a career in sport. I had creative limitations in terms of getting involved in the media or advertising and so on. And so the two paths that remained open to me, certainly as far as I could see as a teenager, were either an adjunct field, which would bring me into regular contact with these other fields that I was so passionate about, or to get involved in a full-fledged career in writing, which would obviously involve an overlap and interaction with these subjects. That's kind of how it started. And it became very clear to me by the time, say, I was perhaps 16 or so, that intellectual property was a good space to get involved in simply because of the amount of overlap it had with things that I was in any event interested in. And so I've said this before, and I mean it honestly. I was more certain that I wanted to become an intellectual property lawyer than I was certain that I wanted to become a lawyer at all. Because had I not wanted to be in this space, I might have done just something else that was engaging me in these subjects that I was interested in. And the law was just a means to get there. So that path has been very clear in my mind. And again, I've told this story before, but I don't mind repeating it for you. In our high school yearbooks, we would be required to give these short descriptions of what you're interested in and what you're looking forward to doing, and so on.
Right.
And if you can go back and find the entry from that year, whatever year it was, 2003, 2004, when I graduated from school, I think you'll find that there is a statement there which says that Eashan wants to be an intellectual property lawyer. So that idea was very fully formed at the time that I was 16, 17. And the rest of it has just been in pursuit of that direction and of that journey, I suppose.
That is very, very interesting because, very few people have a clear-cut idea in terms of what they want to do.
Yeah. No, I'm grateful that it has landed that way. And I'm very grateful also, I think more than anything else, people who sometimes land in those spaces sometimes end up in a situation where it's a little difficult for them to break out of it because it has been preordained for them. This is something that I exercised as an actual choice. There isn't a lawyer in my family for miles on either side. So this was very much my career path. And, sometimes we've had instances, and I'm sure that your viewers and listeners will be familiar with this as well, is that when it does get preordained for you, say if you do have a senior or a parent or a family member in the legal profession in particular, it can be foisted upon you a little bit. And people often run out of enthusiasm because, that's the only life that they've known. So by the time they get to the point where they're 10, 15 years into the profession, that spark is gone. And I think I'm very fortunate for no reason that I can attribute to my own doings, that I still hear, like when I wake up in the morning, I still hear a very loud, resounding ding in my mind that this is what I want to do. It's a blessing to be in that position. I'm very aware of that.
I mean, I think we've had very similar things because I had a great leaning towards sports as well,
Mm-hmm.
and for the very same reasons, I backed out of it. So
Yeah.
it is true, and yeah, like you said, if it is preordained, it's different.
Mm,
But all said and done, it is not easy, even if you have chosen a path to reach a point where you're able to do something with it. I mean, I'm sure many of us want to do certain things. We have a plan for that, and there's a lot of work that goes into it. Right? I'm sure in your case it must have been the same, especially given that there is no lawyer in the family for as you said, miles on the other side.
right.
So what did it take to actually? And this is not a very easy line, if you ask me. I mean,
Mm,
normal stuff, core law, everybody gets into. That's not that's different. This is a
mm,
little different because kind of specialized in a particular field because you wanted to.
mm.
So what exactly did it take to reach that point where today you are a successful professional in that field?
That's a difficult question to answer because I can't attribute individually offhand how much individual factors may have played into into the path that I'm now on. But I can take a stab at answering it. I think two things come to mind. The first is that I think when you face any kind of challenges, any kind of setbacks, you've got to be very clear about persisting and trying to find solutions that may seem less than ideal in the short term, but will work out for you in the long term. And I
Mm,
went through this process a lot during my undergraduate studies, where there were pulls and pushes of all types, a lot of them involving my peers, a lot of them involving my seniors, and so on, where because the world is presented to you at just while you're graduating out of law school, to stick with that path is actually quite a challenging process. And you go through these experiences, and oftentimes you go through them just for the sake of those experiences, where they do appear to be quite attractive to you. So, for example, if you have a career in corporate law that is presented to you, and this is a common story across graduates of law colleges these days, is that you want to shoot for that initial, lucrative first job, or you want to shoot for
yeah.
something that looks attractive on the surface. And to have the clarity to be able to say, no, while this is attractive, this is not something I'd like to do at this time, and perhaps it's something I can revisit later, is
Hmm.
something that I think takes a lot of internal conviction. I don't know, like I said, the reason I have difficulty answering this question is I don't know where that conviction comes from, apart from the fact that it's already there. And so to talk you through that process is a little difficult for me.
Difficult.
But that's one thing that certainly comes to mind is to have that clarity of process. But the other thing that certainly emerges sort of foremost in my mind is to do with really immersing yourself in a lot of these subjects within the discipline itself. So intellectual property is something that gets bandied about. It's become a fancy term these days. But one of my prevailing theories about intellectual property, and I've gone over this as a large part of my teaching experience as well, is that I often ask my introductory classes, in one of my introductory classes, I'll often ask, well, what is the underlying theory that connects all of intellectual property? And
Hmm.
my sort of line breaking answer to that question is that there isn't anything, because these fields are so different within
Yes.
themselves that you need very, very different skill sets to succeed as a patent lawyer, as a trademark lawyer, as a copyright lawyer, as a design lawyer,
Yeah.
as a
Hmm.
lawyer who specializes in geographical indications or in traditional knowledge and so on. These fields have, in my view, they have got nothing to do with each other apart from just this vague underlying idea that because it is, human intellect and there's a manifestation of human intellect, they deserve to be protected somehow. And so, what became very apparent to me once I got my hands dirty in the field is that in order to succeed across the board, I need to get better at many different things that I didn't think came with the deal in the first place. So, like I
Mm.
said at the start, I wanted
Yeah.
to get involved in it because I wanted to work on, say, media cases, or I wanted to work on copyright, or on artists, or on music, or on sport. But very soon I realized that, well, if I wanted to become a good patent lawyer, uh, none of those things that had initially drawn me into the profession would be useful to me in resolving that problem that is in front of me. And so I had to retreat to my high school books to try and understand chemistry and organic chemistry and these really complicated things
Oh,
that, in a sense,
right.
that I'd run away
Mm.
from.
Hmm.
as a primary career path, but then I found myself confronted with them even as part of the path that I'd chosen. And so to be able to push through that barrier where you suddenly get confronted with something that seems overwhelming or something that you don't think you're good at the first instance, and to overcome that and to get past that and to figure out, this is the reason why I'm doing this. And that there's going to be something positive that comes out of it on the other side. I think that's another big part of it, as far as I can tell, certainly.
Yeah. So we'll talk about your book.
Sure.
You know. So I think the first edition came out a couple of years back, and the
Hmm.
other second one came out, I think, in end of 2023.
Yeah, so I think 24 is
Yeah,
when it went to market.
24
Yeah,
is,
we were
yeah, right.
done with, yeah, by the
Yeah.
end of like.
So what was the trigger to write that book?
Good question. So, well, I had a couple of things in mind that I can identify as sort of the immediate triggers for writing it. But the story behind how it came to be is slightly different, and I think that both answers sort of play into each other. But I'll
Yeah.
address the direct question first. Um, when we got involved in the nitty-gritties of trademark law as
Hmm.
practitioners, what we realized was there was a lack of guidance and there was a bit of a vacuum. And this is not to throw shade at anybody who'd already written a book on trademark law in the past, but I would manage to identify, and I'd written about this extensively in the preface to the first edition of the book, is that I managed to identify a few persistent criticisms of long-form Indian writing on trademark law that had come
Hmm.
before mine. I'll just go over a couple of those criticisms. Perhaps
Sure.
some conversation can come out of that. The first criticism that I identified that really struck me was that most long form writing, whether it be the form of books or monographs or whatever it be, looked at trademark law as a whole and insisted on presenting it as a commentary on the sections of the Trademarks Act. Now,
Hmm.
as far as this travels, it's not a bad approach because, at the very minimum, what you're trying to guarantee to the reader, I suppose, is that you're presenting the subject matter comprehensively. So, if there's 150 odd sections in the Trademarks Act, and you put in a little bit of your own commentary on each, and you try and cover case law and so on and so forth,
Right. Right.
I think
Yeah.
what you'll end up with is a very high floor work, but perhaps a low ceiling work, right?
Hmm.
So it'll be something that will have that broad based appeal in the sense somebody picks it up of a book rack. They'll be able to identify, look, this is broadly what trademark law in India looks like.
True. Mm.
But the difficulty that I had with that approach is that I wasn't interested in a lot of the material that was in books like that, which often ran into 2, 3,000, 4,000 pages.
True.
But I wanted more insight on the things that I was interested in, and I didn't find a lot of that insight there. So that was one sort of consistent criticism that I thought that I could make a few years into the profession of what I could look at long form writing and where it was falling short.
Hmm.
The other difficulty I had, Gauri, was to do more with what I call and what I have called in the preface as well, what I've called the reporter's paradox. So when you're dealing with something that is complex subject matter and it is written about in that same sort of dense, slightly inaccessible style, which a lot of our judgments are, unfortunately, I think in
Right.
reporting them accurately, most authors tend to take the safe road, which is that they'll just report them in those words. And so, to beginners or to people who are looking to get behind some of those concepts, those texts become quite impenetrable. And
Hmm.
there's a big struggle involved in trying to decode this and trying to, put it in a style that's either a summary of those points or, something that's a little simpler to understand. And more importantly, to fit it within the broader meta of where it actually belongs, as far as the broad position of that subject matter within the broad position of trademark law is concerned, to put it in slightly clearer language. And so I found that to be a consistent problem with all the material that I would read on trademark law in order to, for example, to prepare for my cases or to advise clients and so on.
Right.
So
Mhm.
those are two broad criticisms that I identified, and I thought, like I said, the personal reasons for writing was slightly different. But those are two things that immediately jumped out to me, is that perhaps I could do a slightly better job with this and to be able to address those criticisms. And I think part of the motivation for writing Imperfect Recollections, so certainly a large part of it, was to be able to address these criticisms that I thought that I could make of what had already gone before.
I'll give you my 2 cents on this.
Sure.
It was a book I could read easily.
There you go. So, well, to the extent that I have attempted to address that criticism, I have at least one fan. So I'm glad.
No, no. I mean, what you said is right. I mean,
Hmm.
so we have been publishing legal books and for quite some time now. While we do publish those books, it's very difficult to read them. I mean, I know we do, but how much of it actually makes sense? So what happens is at some point you start looking at it in terms of is the flow okay? Are the the citations put in place correctly? Are the references there? So it's very difficult to read it and make sense of it, especially some of the commentaries are very
Yeah.
difficult. So there are some books which make easy reading, there is no doubt, and it gives you a lot more information, a lot lesser of a space.
Mm.
So this is one of them. So yes, and in that sense, it made a difference. One question on the book again,
Mm.
the reason for the name.
Okay, so this goes back to an old test under Indian trademark law,
Mhm.
which identifies who is the person that you're talking about when you're looking to compare the similarity between two trademarks. And this is the core inquiry in most trademark registrations that get challenged or in most
Yeah.
trademark infringement claims where there are two trademarks to compare. And one of the standards that came out of Indian courts and hasn't completely left us, even though we don't apply it in perhaps the same sense anymore, is that you're looking at a person who is obviously an average person, a person of average reasonable status,
Mhm.
somebody who's not an extreme specialist in the subject matter, or not somebody who's extremely keyed into the minute differences between the products in that field. And the phrase that emerges from that early case law is that it has to be an average person of imperfect recollection. So that phrase has stuck with us in the law for
Okay.
more than half a century now. And I thought that in bringing out what is effectively the core of the book, and I can talk about this more if you like, but the core of that book is centered around those two chapters on trademark similarity. And when I was thinking of what might be an appropriate title for the book, it just came back to me that it might be a good place to go. So imperfect
Oh,
recollections
nice.
come from that legal test.
Oh, great. Okay. I mean, we did speak about this, I think, when I asked you
Hmm.
the same question. Yeah, but it's good for our viewers to know.
Yeah.
Now, I would like you to talk a little more about your book,
Hmm.
the what you cover in the book, and I mean, what you can speak about the cases. I know that there's stuff you may not be able to speak, but whatever you can speak.
Okay, sure. So
Mhm.
the book is, I think it's very obvious to me as somebody who's put it together, but I think it's pretty obvious to a reader on first or second look that there are about 6 chapters that perform basically the first half of the book that
Mhm.
cover 3 subject matters. The first of these is jurisdiction, which is the question of where do you file suit in trademark law when you choose to file suit.
Right.
It's a very complex question. The second of these is what happens to trademarks after they get registered. So post-registration proceedings, which can often turn into, for example, cancellation actions or enforcement actions and so on. And the final thing, which is something I've already alluded to previously, which is what is the test for trademark similarity, right, in the broad sense. So wherever it arises in the trademark context. So I think if you answer those 3 questions and you give somebody a working understanding of those three questions or those 3 subjects, I think you've gone a long way towards addressing the most likely questions that they might have on trademark law. The rest of the book was actually written for the book itself. So again, to sort of go back into the early story, um, I wrote the 6 chapters that I'm describing on the two on jurisdiction, the 2 on what I've called rectification actions, and then
Right.
the 2 on trademark similarity. Those 6 chapters were written in, I think I timed it at 138 days across a summer, a few years prior to publication. And what I didn't know at the time was that I was writing a book at all, because all I knew at the time was that when we were preparing for cases or when we were advising clients, we were continually running into the same issues over and over again. And what I was finding that my teammates and I at the time, we were redrawing the wheel way too much in terms of
Mm.
digging out research and digging out propositions that we could put on a document to be able to show a court or to be able to show a client. And so I thought there must be an easier way of doing this. And that's when I decided, what if we just, identify a few materials that are getting a lot of traffic in our
Mhm.
discussions that we could possibly reduce to writing and just come up with a coherent narration of these things from the perspective of, well, okay, here's some Supreme Court law on the subject, here's some High Court law on the subject, and so on. So once I committed to that bit, um, that process of putting everything together took, like I said, it took about 138 days and nights to put
Yes. Yeah.
together. But at this stage, I still didn't know that I was writing a book. I just wrote it as research, as like a body of research that I would have that would make my life easier, would make my work easier. And then when I finally got the call to write the first edition of the book in 2019, which was the book that came out in summer of 2020, what I realized was that those 6 chapters alone weren't going to cut it. But having already gone along the lines of trying to identify what were the most frequently litigated subjects in trademark law, I decided that was a good heuristic to be able to apply to find other materials that would also broadly respond to that definition. So
Mhm.
that's how the rest of the book came together. So when we talk about distinctiveness of trademarks, so when we talk about post-registration actions, or when we talk about defenses to trademark infringement, or we talk about injunctions and reliefs and remedies and so on. Those are all things that have experienced a lot of traffic in Indian courts in
Mhm.
the process of trademark litigation and in the process of course, settling big controversies in trademark law. So that's how the book got structured. And I think the putting together of it was a slightly rushed process in the first instance. And it's something that we went back and revisited and pulled apart and
Yeah.
went through for the second edition. And I think that the second edition reads better than the first just for that reason alone. But then the impetus for the second edition was obviously there was a big change to the manner in which trademark law is administered, because we had the Tribunals Reforms Act of 2021, where Parliament, in a very short period of time, decided that they wanted to change how they and effectively re-administer how trademark law, especially as far as trademark registrations, etc., are governed across the country. And it was the returning of that jurisdiction back to the high courts and the consequences that came with it that became the impetus for the second edition. And what I realized
Mhm.
was that there was a lot more than just that individual change to revisit. As I went deeper and deeper into that process, I realized that my own, my own opinions and so on had shifted quite a bit since I did in the first edition. And so the 4 years between 2020, which was the first edition, and 2023-24, which was the second edition, was a lot of revisiting and a lot of just assessing my own work. But I think it says something to how quick the field is moving, that I think eventually when we
Yes.
pulled curtains on it, I realized that over 50,000 words of new writing had made the cut for the second edition, which is a lot in a book of that
It's,
size.
yeah, it's
So
a lot. It
it's a
is,
lot.
it's a
So
lot.
and that's when I realized that this is something that was definitely worth pursuing and possibly might become the subject matter of future editions and so
So on the same subject, since you mentioned that,
on.
how is I'm using a broad term. How is the trademark law evolving?
Hmm.
You said it is, I mean, we know it's evolving very quickly, no doubt about it. How is it evolving, and what do you see in terms of, what changes could come about, or what the expectations are, if we can talk about it, that is.
Hmm. Okay. Well, so two things come to mind. The first is that I think we're becoming a lot more granular in
Mhm.
terms of identifying what I like to call real world market segmentation. So I think trademark law is becoming more and more responsive, increasingly responsive to the idea that our traditional understandings of markets that we have carried in a legal sense for a while are no longer really corresponding to those things as we understand them. So to just give you one example, in trademark law, the manner in which we administer trademark registration is that we divide the entire universe of products and services to which you could apply a trademark, conceivably apply a trademark, into 45 classes. Okay, so there's 34, 35 classes of goods, and then there's
Mhm.
another 10, 11 classes of services. Okay, um, and for the longest time, the simple rule that has governed that administration and continues to do so in a formal sense is that if you apply for a trademark registration within one of these classes, so for example, if I apply in clothing or if I apply in food
Yeah.
products or and so on,
Mm.
then I get an exclusive right to use the trademark with respect to those products and services, right?
Right.
That I register the trademark for.
Right.
Now, this is, of course, and it must be for the purpose of clarity and for the purpose of continuing to administer trademark law, it must be the manner in which we understand trademark rights to work. Like there is no other alternative mechanism by which it would reasonably work.
Right.
But what we're increasingly seeing, Gauri, is that even within classes, because the
Mhm.
classes themselves are so broad, and because consumers themselves know so much more about individual classes, we are starting to see what we call parallel registrations, or registrations with very little difference from each other, being registered in the same class and being allowed to coexist in the same real world market. Um, because of the fact that those markets themselves are segmenting so much, and because consumers' choices and people are becoming more intelligent. So that old
Correct.
parable that I told you about the average person with imperfect recollection, the
Right.
reason that's becoming a bit of an anachronism these days is because the standards that we're applying to judge trademark similarity, as far as the consumer is concerned, are actually very different from what we started out with. So we're talking about very savvy consumers, very tech-heavy consumers, people who know
Absolutely.
the higher end of the market, who know the lower end of the market, who are able to tell products apart based on prices, who are able to tell products apart based on visual appearance and so on.
Yeah.
So that's definitely one area where it's evolving at such a rapid pace that I think that any attempt to pin it down, and this is one of the challenges that we had in writing the second edition as well, is that it's going to be difficult to be able to pin it down with any accuracy because the law will have shifted again in 2 years or 3 years' time.
Right.
That's one. The other thing that really strikes me about Indian law in particular is that we're a very strange and very eclectic confluence of a lot of different influences, right? So
Mhm.
a lot of our old laws, I'm sure you're aware, comes from the old English common
Yeah.
law.
Right.
But on top of that, we've developed a very unique statutory system, which gives sort of almost exaggerated protections to certain categories of trademarks, which is entirely our own. And then we're leaning back into, say, American law to European law to pull in theories about, say, consumer confusion or the level of evidence required and so on. And all of those are now getting applied by Indian judges in Indian context to Indian trademarks. So what we have as a result of that is that not only is it difficult to be able to pin down, okay, this is what a consumer's impression of a product may be in 2025 as we're recording this, but it's also difficult to be able to understand where that law might go doctrinally in a few years'
Right.
time. Because those
Correct.
influences are not going to stop. Because increasingly, as
Yes.
we're turning into a world market, the recent drama on tariffs, etc., notwithstanding,
Yes.
I think what we're increasingly looking at is a world where um, just trying to isolate what are quote unquote Indian standards or domestic standards for trademark law is a silly exercise. I think
Yeah. Yes.
those influences are global, and they will enter our law, not just steadily, but I think they will enter our law all at once. And I think that's what the next 10, 15 years looks like, is that I think you're going to have not just trademark lawyers, like you think about trademark lawyers as a specialization. I think there's going to be FMCG trademark lawyers. I think there's going to
Yeah.
be
Yeah. Yeah.
pharmaceutical trademark lawyers and so on.
Yeah.
So
Subclassifications.
exactly.
Yeah.
So and I think that that's legitimate because it represents, like I said, it represents the real world divisions of these markets. Because I think
Mm.
trademark law at some level, and this is part of the reason why the feedback on the book has also been so interesting, is that this book's audience, from what I've noticed, is not just restricted to lawyers. I think it's a lot of marketing people getting involved. It's a lot of sales people who are trying to access
Yes.
this, people who are doing MBAs, people
Yeah.
of that persuasion in life. And I get it. And I get it. And the reason it's happening is because I think they also want to try and understand this real world segmentation that they spend their entire lives, fixating on and trying to find small edges and small margins in. Is that being adequately reflected in the law? And I think for about 40, 50 years, the answer was yes, but not quickly enough. And I think that
Yeah.
now, especially in the last maybe 6 or 7 years, certainly, we've noticed that the law is starting to catch up.
Yeah. It's really, really fast now. Really, really fast. And one last question. How are we doing on the pendency of trademark cases in India?
Okay, so I think we have different answers to different parts of that process. So I think when we talk about pendency of cases, we're looking at many problems at once. Right? So you have jurisdictions in India where you can only file trademark suits at the district court in the first instance. There are some other
Right.
jurisdictions in India, Delhi included, and a few other high courts, where you can file directly at the high court. And I think the greater access that you have to higher echelons of the judiciary, the more likely it is that your dispute will get resolved quicker. Okay.
Because.
So I think that progress is being made, and I think it's being documented increasingly. Because one of the big reasons why we have made the changes that we've made to, for example, commercial litigation, is in large part to benefit cases such as IP, which will now move faster and have been moving faster for, well, certainly since the Commercial Courts Act has been in force, almost 10 years at this point. So that's one. I think where we have greater challenges, and even their progress is being made, but I think where we have greater challenges is at the intellectual property offices, right? And this is
Mhm.
not just a problem with the trademark side of it. I think it's also a problem with patents and with designs and so on.
Yes.
is that because we have a gap in terms of the number of people who can sit and scrutinize those applications, and we have not fully automated those processes of scrutiny, we have a large lag, and it sort of goes up and down because, again, the IP office has good years and it has bad years like most professionals. But I think that the struggle that we're having there is that we've encouraged people and we've induced people to try and protect their IP, and I think that that's a good thing. But I think our capacity, our office capacity, our government capacity is still trying to catch up with that demand. And so after a few good years, I think we've suddenly, I mean, currently again in 2025, we're looking at large pendencies and so on. But I think what the IP office is doing well is that they're trying to be transparent about it, and they're giving us, for example, waiting lists, or they're giving us, live updates, or what we call dynamic utilities on the trademark office website or the IP office website. And I think those at least foster a sense of cooperation between the people who are trying to find, outcomes from the trademarks office or the IP office more generally, and the members who are trying to do that work. I don't know if we will ever be able to fill that gap. I think that's a challenge that I think all countries in the world have. But
it is difficult.
Yeah, of course. And of course, like if you're looking at lakhs and lakhs of applications, which we are with trademark law, it's not going to be an easy fix. It's not going to be something that you just put boots on the ground and it just gets done.
Right.
But it's something that I think that the transparency of it is helping, in the sense that at least we have responses that we can give to be able to say, well, look, this is just going to take a while. Or we have processes that we're going to be able to say, look, if you are willing to pay an extra fee, we can expedite this process, like an official fee to the government. Then we can expedite this process and so on. So long as those options are available, and we are sure that everybody's doing their best, then I think that that's probably the best way to think about it. So on pendency, I think that's kind of where we are. I try to give you the positive of it more than the negative of it. But that's because I think
that's fine.
subconsciously, we all know what the negative is, and the fact that that you're waiting for years to get desirable outcomes, or to get any kind of outcome. So,
sure. Thank you very much. It's been a pleasure.
Thanks, Gauri.
Yeah.
Take care.
Bye.
Bye.